Hello friends, in this video I am going to discuss the Lokpal and Lokayuktas Act 2013. The Lokpal and Lokayuktas Act, or simply the Lokpal Act, is enacted by the Parliament in 2013 to curb the pervasive and rampant corruption. Since this act is exclusively focused to corruption, therefore it is also known as Anti-Corruption Act. However, before discussing the provisions of this act, let us understand first what is the Lokpal and Lokayuktas Act 2013 all about. It is an act to provide for the establishment of a body of Lokpal for the Union and Lokayukta for the states to inquire into allegations of corruption against certain public functionaries and for matters connected therewith or incidental thereto. Now the question is, what is Lokpal? As defined in section 3(1) of this act, on and from the commencement of this act, there shall be established for the purpose of this act a body to be called the Lokpal. Further, Section 3(2) of this Act states that the Lokpal shall consist of a chairperson who is or has been a Chief Justice of India or is or has been a judge of the Supreme Court or an eminent person who fulfills the eligibility specified in clause B of subsection 3 and such number of members not exceeding 8, out of whom 50% shall be judicial members, provided that not less than 50% of the members of the Lokpal shall be from amongst the persons belonging to the scheduled castes, the scheduled tribes, other backward classes, minorities, and women. Further, Section 3(3) of this Act states that a person shall be eligible to be appointed as a judicial member if he is or has been a judge of the Supreme Court or is or has been a Chief Justice of a High Court, as a member other than a judicial member if he is a person impeccable integrity and outstanding ability, having a special knowledge and expertise of not less than 25 years in the matters relating to anti-corruption policy, public administration, vigilance, finance, including insurance and banking, law and management. So these are the basic qualifications to be a member of the Lokpal. Further, Section 3(4) of this Act further elaborates the qualification or eligibility of the chairperson or member of a Lokpal, and it states that the chairperson or a member shall not be a member of parliament or a member of the legislature of any state or union territory, a person convicted of any offense involving moral turpitude, a person of less than 45 years of age on the date of assuming office as the chairperson or member as the case may be. Next, a member of any panchayat or municipality, a person who has been removed or dismissed from the service of the union or a state and shall not hold any office of trust or profit other than his office as the chairperson or a member, or be affiliated with any political party or carry on any business or practice any profession. So this is all about the eligibility, who can be and who cannot be. Further, Section 4(1) of this Act states that the chairperson and members shall be appointed by the President after obtaining the recommendations of a selection committee consisting of the Prime Minister as chairperson, the Speaker of the House of the People as member, the Leader of Opposition in the House of the People as member, and the Chief Justice of India or a judge of the Supreme Court nominated by him as a member. Now, the question is, what is the jurisdiction of inquiry of Lokpal? As defined in Section 14 of this Act, subject to the other provisions of this Act, the Lokpal shall inquire or cause an inquiry to be conducted into any matter involved in or arising from or connected with any allegation of corruption made in a complaint in respect of the following, namely, Prime Minister, Ministers, Members of Parliament, Groups A, B, C and D officers, and officials of central government. Likewise, Lokpal can inquire to all these people and posts. However, there are certain conditions and limitations while inquiring the Prime Ministers. Further, Section 35(1) of this Act states that the central government shall constitute such number of special courts as recommended by the Lokpal to hear and decide the cases arising out of the Prevention of Corruption Act 1988 or under this Act. Now, the question is, what is procedure of removal and suspension of chairperson and members of Lokpal? As defined in Section 37 of this Act, the Lokpal shall not inquire into any complaint made against the chairperson or any member. Next, subject to the provisions of subsection 4, the chairperson or any member shall be removed from his office by order of the President on grounds of misbehavior after the Supreme Court on a reference being made to it by the President on a petition signed by at least 100 members of Parliament, has on an inquiry held in accordance with the procedure prescribed in that behalf reported that the chairperson or such member, as the case may be, ought to be removed on such ground. It means Lokpal itself cannot inquire on any complaint against the chairperson or any member of the Lokpal. The second provision is saying that in order to remove the chairperson or any member of Lokpal, primarily a petition needs to be filed in the Supreme Court that has to be signed by 100 members of Parliament and subsequently inquired. Lastly, based on the recommendation of the Supreme Court on the grounds of misbehavior, the President can pass the order of removal. Further, Section 46 of this Act states that, notwithstanding anything contained in this Act, whoever makes any false and frivolous or vexatious complaint under this Act shall, on conviction, be punished with imprisonment for a term which may extend to 1 year and with fine which may extend to 1 lakh rupees. Further, Section 63 of this Act states that every state shall establish a body to be known as Lokayukta for the state, if not so established, constituted or appointed by a law made by the state legislature to deal with complaints relating to corruption against certain public functionaries within a period of 1 year from the date of commencement of this Act. Now, let's check out certain facts about Lokpal Act. Following are the important facts. The term Lokpal was first used by Lakshmi Mal Singhvi in 1963. The word was derived from the Sanskrit words Lok, meaning people, and Pala, meaning protector, caretaker. So, the overall meaning, that is caretaker of people. The Lokpal Bill was first introduced in the Lok Sabha in 1968. Maharashtra was the first state to introduce Lokayukta through the Maharashtra Lokayukta and Upa-Lokayuktas Act in 1971. Next, the bill is an implementation of the Prevention of Corruption Act 1988. The version enacted in 2013 was from a draft prepared in 2010. At present, there are no Lokayuktas in the states of Andhra Pradesh, Arunachal Pradesh, Jammu and Kashmir, Manipur, Meghalaya, Mizoram, Nagaland, Sikkim, Tamil Nadu, Tripura, and West Bengal. So, this is all about the Lokpal and Lokayuktas Act 2013.